Regarding question number 6, while discussing the concept, capacity, and form of marriage, also discuss the proof of Muslim marriage. And question number 7, examine the salient features of a valid marriage under Muslim law. And question number 8, the two basic requirements in Muslim law for legal competence to freely contract a marriage or sanity and puberty. While discussing the nature of Muslim marriage, also discuss the classification of Muslim marriages under Sunni and Shia law. Write a critical note on Talaqi Hasan, Talaqi Hasan, and Talaq al-Bidat. Can husband divorce his wife without her consent and without assigning any reason under Islamic law? Express reason for your answer. And question number 10, it is said that under Muslim law, any husband who is sound mind and has attained puberty may divorce his wife whenever he may wish. Discuss the husband's right to divorce his wife. And question number 11, discuss the grounds on which marriage can be dissolved by the Muslim wife under the provisions of Dissolution of Muslim Marriage Act 1939. Discuss the various grounds and procedures provided for divorce under Muslim law. And question number 13, with the help of decided cases, discuss provisions of Muslim women protection of rights on Divorce Act 1986. And question number 14, examine the concept of cruelty, desertion, and polygamy as valid grounds for maintenance of Muslim wife. So, to regarding the very exact and precise answers, as already we have discussed in our previous uploaded videos regarding the Muslim marriage and divorce. So, now we'll give certain brief ideas on the very concept and validity of Muslim marriage and on divorce. So, regarding the very concept of Muslim marriage, as we found under Islam, Nikah, the very concept of marriage is a form of permanent marriage, and as it is on the very concept of contract, so it is a contractual concept of marriage under Islam, and the very prerequisites for a valid nikah, as we found, there must be a proposal which is called ijab from the bridegroom, and when the bride accepted the proposal, then it is called kubul, and there must be presence of some witnesses, and there must be a price in consideration of that marriage. There must be presence of wakils, and the very marriage or nikah must be performed by a kaji. There must be recitation of certain Quranic verses, And lastly, there must be a nikah or marriage deed. And when the question of sanity and purity arises also, there is a requirement of consent and capacity to marriage. And when it is the question of consent, it must be free and voluntary. And in cases where the bride or the bridegroom or minor, then there is the requirement of consent of the guardians, and that consent must be communicated to each other parties, and there must be a soundness of mind of both the parties. So there is another requirement attaining of purity, and there are certain prohibitions or impediments such as the absolute impediments and the relative impediments. And regarding that, those absolute impediments or prohibitions on a nikah, those are the prohibitions on the grounds of consanguinity or affinity or fosterage. And regarding the relative impediments, one is unlawful conjugation, and the second one, if the very bride is undergoing the period of iddah, or if there is differences of religion between the bride and the bridegroom, and if there is a marriage with a fifth one, and so also those marriages on pilgrimage, and besides that there is a term marriage which is called muta marriage, and that is prevalent among the Itna Azhari schools of the Shias. And regarding divorce, that is in Islam is called talaq, and the very section 2A of the Muslim Women's Protection of Rights on Divorce Act 1986 defined, and that regarding requirements of that there must be capacity of giving talaq, and there must be attainment of majority age. And regarding talaq or divorce, we found the dominant position of the husband, and there are different forms of talaq as we found under Islam, and all it must be under a talaq nama. And besides that, we found under Islam unilateral divorce, divorce by mutual consent, also judicial divorce. And when it is divorce at the instance of the husband, then it is called talaq al-suna, and that talaq al-suna is of talaq hasan and talaq hasan, and the second form is talaq al-vida. And when the divorce is at the instance of the wife, then it is either called ila or jihar or khulla or khul. And regarding delegated divorce, we found one form, that is talaq-e tafiz. So also there is another form of divorce at the instance of the wife is called lian, and there also another form of divorce that is called mutual divorce, and under Islam it is called mubarak. So also we found dissolution of Muslim Marriage Act 1939, and that is otherwise we call judicial divorce, and that is on the very fault grounds of divorce and regarding fault grounds of divorce where the husband's whereabouts is unknown for 4 years or failure to provide maintenance for a period of 2 years, and such grounds or falling under false grounds also any sentence to husband 7 or more years of imprisonment or failure to perform matrimonial obligations. And when there is impotency of husbands also insanity, leprosy, venereal diseases, so, under these grounds, there can be divorce and also repudiation by wife on the grounds of cruelty of husband. And besides that, there is another theory that is breakdown grounds of divorce theory, and in that connection there are non-payment of maintenance on account of the conduct of the wife, and otherwise the second breakdown grounds of divorce theory, there is the total irreconcilability between the spouse. So, such are the provisions we found under traditional classical Islamic law on talaq or divorce, so also under the Muslims Dissolution of Marriage Act 1939, so also under the Muslim Women Protection of Rights and Divorce Act 1986, and in our next round of questions on Mohammedan law, we'll discuss regarding dower or meher and hiba, the gift, etc.